welcome everybody to Curtin University's inaugural Human Rights Lecture. We are honoured tonight that this important lecture will be delivered by the inspirational Gillian Triggs, and I think a person who we would all agree has so impressively taken on her important role without fear or favour. As Professor Triggs will discuss later, education plays an absolutely key role in reimagining Australia, where human rights are fully realised and enjoyed by all. Indeed, this annual lecture was established to encourage a strong human rights culture both within and outside our university. The responsibility we all share in this respect, I think, has been beautifully captured in some remarks that Eleanor Roosevelt made at the United Nations in 1958, and I quote, "Where, after all, do universal human rights begin? In small places, close to home, so close and so small that they cannot be seen on any map of the world. Such are the places where every man, woman and child seeks equal justice, equal opportunity, equal dignity without discrimination." For us here at Curtin, our responsibility in this important area pervades, I think, everything that we do. And I'll just give you a few examples. The focus of the research, the scholarship, the education and the advocacy undertaken within the University's Centre for Human Rights Education is very important, and I congratulate you, Baden, and your colleagues for the excellent work that you do. I would also acknowledge our commitment through the work of our ethics, equity and social justice area to facilitate an inclusive and socially just environment for all of our staff and all of our students, irrespective of their gender, their ethnicity, their age or their physical or social circumstances. And our work in what we refer to as the AHEAD program, addressing higher education access disadvantage, a program that has attracted significant funding from the Commonwealth Government. And I'm just, before I introduce our keynote speaker, going to just give you an example of one of the projects under the AHEAD banner, and it's called Row Ahead. It uses rowing as a way of breaking down barriers and giving Aboriginal students from the Clontarf Aboriginal College greater confidence to pursue higher education. And obviously not many people actually associate Aboriginal people with the elite sport of rowing. And that's actually not surprising, given that only 0.1% of rowers in Australia are Aboriginal or Torres Strait Islanders. But the Clontarf Row Ahead students have not only broken through their own personal barriers, but also community ones, and they were in fact the first Indigenous crew in Australia to take part in a state regatta. The irony being, of course, that the Whadjuk people of the Noongar Nation were traversing our rivers for centuries before we arrived. But it's taken a century or two for them to compete in the sport of rowing, a sport that I think is so often associated with our privileged educational environments. And as one of the participants said, and I quote, "It has made me think that maybe I can start to do more things that I thought I couldn't do." For me, this was a reminder that we, as university staff and as universities, should never lose sight of the power of education to change the lives of individuals, one person at a time. But by doing so, we transform our communities and we help to build a fairer, stronger and more globally competitive and responsible Australia. So on that note, I'm absolutely delighted to formally introduce our guest speaker, Professor Gillian Triggs. She is, as we've heard and as we all know, currently President of the Australian Human Rights Commission, a role that she took up in 2012. Prior to then, she was Dean of the Faculty of Law and the Challis Professor of International Law at the University of Sydney, roles that she held from 2007. Prior to that, Director of the British Institute of International and Comparative Law. She's also a former barrister and a Governor of the College of Law. She has combined an academic career with international commercial legal practice and has advised Australian and other governments and international organisations on international, legal and trade law and disputes. Her focus at the Commission is on the implementation in Australian law of the human rights treaties to which we are a party, and to work with nations in our region on practical approaches to human rights. Since her appointment, she's been a fearless advocate for human rights, ranging from her support for the Safe Schools program to marriage equality, through to her calls for the monitoring of conditions for asylum seekers and refugees in offshore detention centres. The following quote by Professor Triggs in a recent media interview, I think, is a very telling observation of her approach, and I quote, "When I was younger, I thought one could build on the past, but I've learnt that we need to be eternally vigilant in ensuring human rights in a modern democracy." Gillian, we respect you hugely for your approach. We admire your achievements. We're privileged that you agreed to be with us this evening, and we're looking forward to hearing from you tonight. Thank you very much.
Good evening, everybody. It's wonderful to see so many of you here, and thank you for that wonderful introduction from the Vice-Chancellor, Professor Terry, Professor Offord. Can I recognise in particular the Honourable Minister Parks? It's wonderful to have you here, and thank you, Ted, so much for your welcome. I hope that I can take your spirit with me for for this year and for what remains of my term next year. I greatly value your offer of spirit and your understanding of what it is that we all try to do at the Australian Human Rights Commission. Well, may I also, of course, in this wonderful lecture theatre named after, of course, a favourite author of mine, Elizabeth Joly, can I acknowledge the Nyunga people, the traditional custodians of the land on which we meet, and I pay my respects to their elders past and present. Well, I was, of course, very honoured indeed to have been invited by the Centre for Human Rights Education to present the inaugural Curtin University Human Rights Lecture. And the aim of this, what is to be an annual lecture, is a very important one. It's to consider how Australia can ensure a resilient culture of human rights, and the Centre has focused on this theme for the year, reimagining human rights in Australia. Well, in rising to this challenge posed by reimagining, I note that we're in a caretaker mode prior to the election. I'll do my very best to avoid political controversy, and I hope that what I have to say is not so bland that it's to leave you bored and restless and wishing you hadn't come. Well, our mission, of course, at the Australian Human Rights Commission is to ensure human rights for everyone, everywhere, every day. The universality of human rights is a cornerstone of our understanding of rights. Human rights are for all people, regardless of race, creed, or any other characteristic. While this aspiration has been realised for many, if not all, or most Australians most of the time, it remains an unattainable aspiration for the vulnerable groups in our community: Aboriginal and Torres Strait Islanders, those with disabilities, older Australians, the LGBTI community, and the thousands of asylum seekers who've sought our protection. I suggest that Australia fails to meet our international human rights obligations under the treaties to which we're a party. And tonight I'd like to look at those areas where Australia is in serious breach of human rights law and consider how it has happened that Australia has become exceptional and even unique among comparable nations in our approach to human rights. The idea of reimagining human rights, of course, implies that human rights need to be reimagined, and I believe they do. The sad death last week of the 17th suicide victim in the last 5 years of a refugee or asylum seeker, either in detention centres or in the community, and most particularly from Nauru and Manus, followed even yesterday by what appears to be another suicide victim, along with the continued detention of over 1,500 people, including 50 children, on Manus or Nauru, provide a stark reminder that Australia remains in egregious breach of the fundamental right not to be detained arbitrarily. And may I remind you, because it was only last year that we celebrated the 800th anniversary of the Magna Carta, that buried in the middle of that document from 1215, along with the volume of wine in a glass to the breadth of a piece of cloth to widows' rights, right in the middle of the Magna Carta is that extraordinary phrase, "No man may be detained arbitrarily without charge or trial by his peers." These are not modern ideas. They are ideas fundamental to every legal system in the world. But perhaps the most revealing observation about the state of human rights in Australia is the contrast with the laws of Papua New Guinea. Just 2 weeks ago, the Supreme Court of Papua New Guinea found unanimously that detention without trial on Manus Island is contrary to their constitutional right to protection of liberty. And the court called on the government to ban detention on the island. But some weeks earlier, the Australian High Court ruled in the M68 case on the constitutional validity of the government's Migration Act, requiring the removal of asylum seekers to Nauru for processing where they would be deprived of their liberty. The court found that the legislation was constitutionally valid so long as the detention was reasonably necessary for the purposes of processing. But it's notable at that time that no judge, no one of the 7 judges, refers to Australia's international obligations, nor, with one notable exception, did they consider the power of the common law's writ of habeas corpus to protect against executive detention without trial. In short, while removing asylum seekers to another country for the purposes of offshore detention is valid under the Australian Constitution, it amounts to an unconstitutional deprivation of liberty under the more modern 1975 Constitution of Papua New Guinea. Why is it that Australian law fails to provide protection for fundamental freedoms when we are such a successful multicultural democracy with a strong common law system that values the rule of law? Over recent years, and especially the last 15 years, since 2001, which was an extraordinary year, it was the year of the misstatement about children overboard, it was the year that the Tampa sailed into Australian territorial waters, and within a few weeks of that, we had 9/11 and the attack on the Twin Towers and the Pentagon in the United States. And what we have seen pretty well ever since has been a conflation by political leaders of these questions of asylum seeker rights and a fear of terrorism, used and abused, I believe, throughout the world, but perhaps especially in Australia. What we've seen is a steady growth in federal, executive and ministerial discretion that is not for practical purposes reviewable by our courts. Parliament has failed in its responsibilities to provide a check on the executive power of government, and it's diminished the judicial role of our judges, threatening the principle of the separation of powers and distorting the checks and balances among executive government, Parliament and the courts. But these are abstract ideas. Let's have a look at some recent examples, bearing in mind that the legal test, both in international law and domestic law, is that the validity of any legislative measure is whether it is necessary and proportionate to achieve a legitimate aim. And let's begin by looking at counter-terrorism laws. Introduced over the last 2 years, we've seen many new provisions introduced that appear to be disproportionate to the needs of national security. And a particular example are the data retention laws that allow security agencies to have access to private data without a warrant. And that is a critical point, because you can actually learn more from metadata about a person than you can from knowing the content of an email, for example, for which you need a warrant from a judge. But you need no such warrant in relation to metadata for access by a number of the security agencies in Australia. We have proposals for stripping of citizenship. We have preventive detention orders and control orders of children, with proposed legislation now that they be extended even further. We have a new COAG proposal to allow post-sentence detention of convicted terrorists after their sentence has been served. We have a New South Wales proposal for pre-charge detention of 28 days. Laws of this kind, which seem significantly disproportionate to the aim, although this will be a matter of balance and opinion. Professor Roach has called this hyper-legislation by Australia that has exceeded either the United Kingdom or the United States or Canada in the number of anti-terrorism laws since 9/11. Australia has passed 65 different sets of counter-terrorism laws since that time. Another area that is of great concern to the Australian Human Rights Commission is the growth in lengthy administrative detention without charge or trial in maximum security prisons of those with cognitive disabilities or who are unfit to plead. And very recently, the hundreds of immigration detention cases involving New Zealanders and others under the Section 501 visa cancellation, where the minister exercises a discretion where the individual is found by him to have failed the character test. One of the many ironies of working in the human rights area is we seem to have created more angst and concern about our New Zealanders being held on Christmas Island than we ever did about the asylum seekers. Another matter of very profound concern to the Human Rights Commission is the alarming rate of detention of Indigenous Australians, with 24% of juveniles in detention being Indigenous and suicide being the main cause of death of those between 15 and 24. Aboriginal and Torres Strait Islander adults are 15 times more likely to be imprisoned in than non-Indigenous Australians. And Aboriginal deaths in custody continue 25 years after the Royal Commission into deaths in custody. The causes are many-fold, but we are very concerned by the rise in the number of arrests for parking fines or minor offences, and I think you've had a particularly tragic case here in Western Australia, and also the rise of paperless arrest laws in the Northern Territory, where we've seen the High Court of Australia again rule that laws of this kind are constitutionally valid. We also, of course, have the continued detention of well over 3,000 asylum seekers and refugees, most of them we know to be refugees, with children continuing to be held in Nauru, and a number of children in Australia vulnerable to return to Nauru. The long-term and indefinite detention of asylum seekers is, in my view, an egregious breach of international human rights law and the provision against arbitrary detention in particular. But we've also seen threats to freedom of speech curtailed by secrecy laws, by on-water security provisions. We've seen the right to freedom of association challenged by the so-called Queensland bikie laws, but also by the West Australia's proposed anti-protest laws that will criminalise the preparation for prevention of a lawful activity or for trespass. We've seen the role of judges to review the validity and application of laws diminished by mandatory sentencing provisions, particularly in alcohol-related cases, but most particularly and insidiously by the significant expansion of ministerial discretion that is not subject to meaningful administrative or judicial review. Access to justice is denied where funding to community legal services has been cut or withdrawn. And finally, there are even examples in which there has been an explicit rejection of international law, where, for example, the Migration Act now provides that a government official who breaches the core principle of non-refoulement under the Refugee Convention will not be vulnerable to prosecution, and the Act will remain an authorised one. Or some might say, why stand up against these relatively minor legislative changes? Most people haven't even noticed them. A lot of them, I might add, are passed in 2 weeks before Christmas. Why be worried? Let's wait until an individual is actually prosecuted. Very few prosecutions have actually been brought under the counter-terrorism legislation, and very few are successful. Well, the Chief Justice of Australia has very rightly countered this argument recently in a speech in which he said, "Each encroachment by statute, regulation, rule or bylaw on common law rights and freedoms is, if taken cumulatively, over time and across state, territory and Commonwealth jurisdictions can be the death by 1,000 cuts of these fundamental rights and freedoms. In short, the whole is bigger than the sum of its parts. We cannot allow a gradual slide into executive overreach or the expansion of ministerial discretion in the absence of judicial oversight. To resist what is an unprecedented extension of government power, we should, of course, understand how this situation has arisen in Australia. And the answer I'd suggest to you is Australian exceptionalism. The failure over many decades of efforts to implement Australia's human rights obligations in its domestic law has left a legacy of isolation from global human rights laws and jurisprudence. Australia's approach to human rights stands in stark contrast to other comparable legal systems where human rights commitments are reflected in domestic laws, in their constitutions and in bills of rights that limit the power of Parliament to authorise the executive to act inconsistently with the nation's international obligations. But before I go further, I should, in all fairness and honesty, recognise that what I see has been a retreat over the last 15 years from our human rights obligations betrays Australia's historical commitment to developing contemporary human rights law. Our commitment to human rights until the last 15 years or so has been one of genuine leadership and commitment. And I must go back to somebody I have always greatly admired, Doc Evatt. Dr. Evatt, Minister for External Affairs, he played a very significant role in drafting the Charter of the UN. He was a strong supporter and negotiator with Eleanor Roosevelt, whom the Vice-Chancellor has already quoted tonight, in drafting the Universal Declaration of Human Rights, which was adopted by the General Assembly without a single negative vote when Doc Evatt was President of the General Assembly. An extraordinary feat for this Australian politician at the time. He also presided over the adoption of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. In the decades following, respective Australian governments have been genuine and active negotiators of the suite of human rights treaties that have been ratified, including, and I would date it up to now, the passing of the statute for the International Criminal Court, which came into force in 2002, where that extraordinary notion adopted in the Nuremberg War Crimes Tribunal, international crimes against humanity are committed by men, not by abstract entities. Each of us is individually responsible for those matters over which we have some effective control. But despite its leadership in crafting human rights law, Australia's introduction of that international law into our domestic law has been piecemeal and very slender and fragile. The Commonwealth of Australian Constitution does not specifically list traditional common law freedoms. The Constitution, as you'll know, respects and protects the right to freedom of to vote, to compensation if our property is unjustly acquired, and of course freedom of religion is protected. All other freedoms that emerged in either as part of the Magna Carta or in the years after that depend for their protection on other legal mechanisms, especially our courts. And it's rested with the High Court of Australia, for example, to imply a right of political communication, a right that does not fully equate to the common law or international law right to freedom of speech. Unlike every common law country in the world, and unlike most civil law countries, Australia has no bill or charter of rights. In the absence of a legislated commitment to fundamental rights and freedoms, we do not speak the language of human rights. With our North American and European allies, including jurisdictions such as Canada, New Zealand, the United Kingdom, United States, South Africa, and much of Europe. While every region of the world, Europe, the Inter-Americas, Africa, and more recently the Arab nations, have established regional agreements, commissions, and courts on human rights. But Australia is not part of any human rights treaty for the Asian region, where ratification of human rights treaties has been slow. The consequence is that there's no regional human rights jurisprudence that could provide a scaffolding for evolving regional norms in our part of the world. The deficits in constitutional protection would not be fatal to the protection of human rights in Australia had Parliament legislated to implement the core human rights to which we're party. It's one thing, of course, for our diplomats to play the widely respected role in negotiating and ratifying human rights treaties, but it's proved to be a totally different thing to garner the political will in federal parliament to pass the legislation to make those human rights obligations binding. And in fact, the key human rights treaties, the International Covenant on Economic Social Rights, the Covenant on Civil and Political Rights, even the Convention on the Rights of the Child, among many others, including the Refugee Convention, have not been implemented as part of our national law. Now, there are three major exceptions, and they are the Convention on Race, the Race Discrimination Convention, now a part of Australia in the Race Discrimination Act, one of the most important human rights instruments Australia has ever agreed to. It's been absolutely fundamental in creating a culture for human rights that I think Australia needs so badly. We've also, of course, accepted and given domestic implementation in relation to sexual discrimination and in 96 to disability discrimination. And interestingly, we have our own national age discrimination legislation that is not matched by an international treaty. So we've been a real leader in relation to those four areas. And some other rights, for example, the right to privacy, are protected by the Privacy Act at the Commonwealth level, and that's proved to be an enormously important giving effect to a human rights treaty because of Article 17 that protects privacy at a broad level, but has also, as you may well know, protected the right of those of a different sexual orientation, particularly in relation to the laws in Tasmania. Well, while human rights then in Australia are, in my view, very inadequately protected either by the Constitution or by domestic legislation, it might be thought that the common law would provide a reliable safety net. For under the common law, Parliament is presumed to have intended to comply with international law and the principles of legality. By far the most powerful principle of statutory interpretation, limiting the capacity of the courts to consider international obligations, is that even fundamental common law rights, such as the right not to be detained arbitrarily or freedom of speech, can always be overridden by clear and unambiguous words to the contrary. If the laws are valid and the language is clear, the courts must apply them. It's for this reason that the common law has not proved to be the effective protection for human rights, for the legislation will often have been so frequently redrafted and reformed that its words are crystal clear and cannot be overcome. And let me give you a couple of examples. One is the, I think now notorious decision of the High Court of Australia in 2004, where a 4-member majority in Al-Khatib and Godwin concluded that the mandatory and indefinite detention of asylum seekers, as required by the terms of the Migration Act, is constitutionally valid. The plaintiff was a stateless Palestinian man whose claim to refugee status had been rejected. No country would or could accept him, with the result that Al-Khatib was detained for 5 years by the Australian government without charge or trial. But because, in the view of the majority of the court, the terms of the Migration Act were so clear, there was no capacity for the court to reach out to either the common law, which of course has a principle against arbitrary detention, or to international treaties that had not been given domestic effect by passing legislation through Parliament. But the Chief Justice was, in this case, in the dissent, and he confirmed the principle that the courts do not impute to the legislature an intent to abrogate or curtail certain human rights or freedoms, unless that intention is clearly manifested by unambiguous language. The problem is that judges will differ as to whether the language is clear, and indeed they did in that case, although you'll probably be aware that Justice Michael Kirby was in the dissenting minority, along with Justice Gummow. Each of those dissenting judges taking the view that the language was ambiguous and you could move to common law freedoms, the majority didn't agree. But the more recent one is the one that I've briefly mentioned, the M68 case. Here, the plaintiff was a Bangladeshi asylum seeker, technically an unauthorised maritime arrival under the Migration Act, and she sought an application to the court for a view as to whether the Commonwealth and the minister acted beyond executive powers under the Constitution by enforcing her detention in Nauru. Well, Justice Gageler recognised that the focus of the case was on the capacity of the executive government to procure or enforce the deprivation of liberty without, of course, charge or trial. But he, along with a 6-member majority, only one dissenting judge, agreed that the legislation was clear. So the courts could not go beyond the words of Parliament. Now, many of you will say, well, that's obvious. Parliament is sovereign. Parliament is supreme. We voted for Parliament. Parliament makes the laws. The judges apply the laws. That's a fairly well understood concept. But what happens to a modern democracy when you have a complicit Parliament where opposition and major parties agree to these provisions which breach human rights law, and they have typically, as the Migration Act does, to prevent the courts from considering the validity of the decision by a minister as a matter of discretion? What happens to democracy then? You've excluded the courts for practical purposes, and you've got a compliant Parliament which will agree to the proposals put forward by the executive. And that, I think, is a very serious danger. Well, what the M68 case does as one of the most recent decisions is to confirm that a key characteristic of Australia's approach to human rights is that Parliament has almost unlimited powers to authorise the government to act where they believe appropriate, inconsistently with the fundamental freedoms recognised by the common law. Well, I've yet to mention, of course, the potential impact of the United Nations monitoring systems and the individual complaints that can be made to the various treaty bodies. But to give you an example of the impact of those findings of treaty bodies, over 36 matters have, over recent years, been brought to the United Nations Human Rights Committee and have been the subject of findings against Australia and Australian law, most particularly, of course, in relation to indefinite detention of asylum seekers. But almost all of those matters, in fact, all of those matters, have been completely ignored by the Australian government. And I've recently returned from Geneva, where we had the second of our Universal Periodic Review by the Human Rights Council, and 104 nations expressed their concerns about 3 matters. The first was offshore processing. The second was the very high rate of Indigenous incarceration and administrative detention. And the third was domestic violence and the loss of lives of women, predominantly women, but not always, were matters all raised within, and I have to say, courteously and briefly and based on accurate evidence, calling on Australia to reconsider its policies in relation to all of these matters. Australia has rejected half of those claims and noted the other half, which is, of course, diplomatic code for saying nothing much is going to happen. But we've also seen that the rapporteur in the Convention Against Torture declared last year that the conditions in the offshore detention centres are in breach of that convention and amount to cruel treatment and punishment. Despite these concerns expressed, as I say, genuinely, courteously and based on evidence, they are rejected by the Australian government, and we know, of course, that the response by a former Prime Minister is that we will not be lectured to by the United Nations. Well, that brings me then to where I really wanted to go with this lecture, and that is, how can we reimagine human rights in Australia? Well, the first and foremost point that I must make as an international lawyer, and based on my last 4 years, is I think we have to reopen the discussion to create a legislated charter for human rights at the federal level. I think you'll all be aware of the work of Father Frank Brennan and his consultations around Australia. He recommended to the then Labor Party that we have a human rights charter, and the government, the then government, considered it, but ultimately the proposals fell into desuetude. It's not a popular issue. Australians have been, sadly, I think, misled into believing that if we had a Charter of Rights at the federal level, that would give our judges an unrestricted right to rule and be activist judges to create new law. And one example of this, when I raise this with parliamentarians, is, well, look what the United States Supreme Court did in the Obergefell case on marriage equality. The United States Supreme Court can go to its Bill of Rights and say, there's the 14th Amendment, the principle of equality before the law, based on a similar principle of equality before the law in the International Covenant on Civil and Political Rights, to which, of course, Australia is a party. But there, the debate across the United States could be resolved by the Supreme Court. Now, I see that as an important role of leadership by the court based upon contemporary jurisprudence on an important matter of national interest. But many, many reasonable and fair minds will say that is not right for Australia. We do not want our judges being able to interpret the law in a way that will create a law for the entire nation. Now, I realise that people have a different view of the role of a Charter of Rights, but I think we need to discuss it in light of what I think have been very significant breaches of human rights and a drift towards isolationism in relation to human rights. Because as we do not have any of the tools for human rights in Australia, we have not been able to speak the same language with our colleagues in so many other countries on these issues. So I think we need to think about it again. It could be something like the New Zealanders have, something similar to the South Africans or the Canadians, where it's legislated. If it was going badly wrong, you simply reform it or repeal it entirely. It would not be entrenched constitutionally. I think the chances of that are very, very slight indeed, if not zero. So a legislated charter, but one which will allow the courts to declare that there might be an incompatibility of a legislative measure with a particular right listed in the charter. Now, you might be interested to know that in New Zealand they've had a charter for about 24, 25 years, and only once has the court ruled that there's been an incompatibility. But what it's done is to create the language of human rights in New Zealand and in Canada and the other jurisdictions I've mentioned, so that everything is viewed through the prism of human rights, because the rights are listed in a charter that every citizen can read and understand. But in Australia, we just don't have it, and we don't have a strong enough understanding of our constitution. So that is my reimagining. I would like to see that debate reinvigorated in Australia to avoid a polarisation of debate. Let's look at whether we'd want to go as far as a US kind of system. Is the New Zealand one better for us? The British or the English Human Rights Act is criticised and may be altered if Brexit is successful. I sincerely hope it isn't. I withdraw that. It's a political statement. But let's look at these examples, but do so not in a polarised way, but in a way of saying, how can we bring Australia into the international legal environment to meet what I think was the vision and the first imaginings of these remarkable politicians that we had in the 40s and the 50s and 60s and 70s. People who wanted Australia to be part of that leadership appreciation of human rights, and who were prepared to take a risk, to take some risk, go ahead of public opinion in some cases, but did so in a leadership way for Australia that brought us into the international community. Now I deeply fear, that we are drifting in an isolated way from that jurisprudence. Well, that's not my only solution to reimagining. I now come really to the core of what I wanted to say, and that is that it comes back ultimately to culture, to normative understandings of human rights, and that comes back to education. By normative, perhaps I can tell you a little bit about what you may have been aware of here in Western Australia, and that was Operation Fortitude in Melbourne. Does anyone recall this? You might remember that our newly created border force decided to issue a press release that they were going to stop people in the shopping malls out in Melbourne to question them as to whether or not they had their visa or passports or whatever. Now, I think it would be fair to say that as I don't live in Melbourne, but if I did, I'd been to David Jones and bought my little parcel, walking down with my pearl earrings and my little jacket. I don't think they were going to stop and ask me where my visa was. This can only have been intended to work on some kind of racial or cultural profiling. But what was wonderful, and despite my telling you a very grim tale tonight, what was wonderful was that within hours of the press release going out into the public, social media responded and said, are you aware that the Border Force officers are going to be doing this? They have no legal right, I might add, to stop and question at all, but nobody appeared to have got any legal advice on this before they issued the press release. And within a couple of hours of that, hundreds of people were on the streets of Flinders Street Station, and within a couple of hours of that, the Border Force senior executives withdrew the press release and said that it had been a mistake. Now, I mention that example because, in a way, human rights are about culture, about what's normative and about what's fair. I know it's a much cliched term, the fair go in Australia, but it actually really means something to Australians. We interpret it differently. We don't speak the language of human rights law. Most Australians don't know about these treaties or understand them. They don't really, sadly, understand their constitution. But they do get the idea of a fair go, and there's a limit. And I think Operation Fortitude gave me some sense that it's the culture that matters, and that brings me really to my point. It's ultimately education. Education is a human right. In the Universal Declaration, going back to Doc Evatt, education is the full development of the human personality and the strengthening of respect for human rights and fundamental freedoms. And it is education about human rights that I think is going to be the most important step. If at the political, cultural level in Australia, we have a higher level of education about human rights, and that is, of course, what I applaud the Centre for doing, I think that is really where the future lies if we can't achieve the aspirational charter that I would very much like to see Australia have a serious discussion about. Education in human rights is a human right in itself. And we've had a take-up of this concept. The Melbourne Declaration on Education Goals for Young Australians by the Council of Ministers on Employment, Training and Youth Affairs sets goals to promote equity through schooling, non-discrimination in the school environment, and to ensure that schooling contributes to a socially cohesive society. The goal also includes ensuring that all young Australians are active and informed citizens, that they appreciate Australia's diversity, acknowledge Indigenous culture, and are committed to equity and justice. Well, human rights education is a core part of our functions at the Human Rights Commission. And we have done some surveys, and we've found that teachers, 98% of respondents as teachers to our survey said it was important to educate their students about human rights. But one of the great difficulties is that teachers have very crowded curricula, and human rights as a legal matter, and it's of course not only legal, can appear extremely complex. Teachers are not typically trained in the law, and they're not trained to look at treaties or to understand how they work. And they lack experience in how to integrate human rights law generally into the curriculum for their particular years. So one of the things that we've been doing at the Commission is to develop resources for teachers that they can download simply by keying in the code number for their curriculum, and we then provide them with materials that they can use. But what I'd like to do is to give you some examples in the time that I have left, to give you some idea of where we're putting our very small budget, but that is into these kinds of video tools that teachers can use and that explain how human rights law can work in Australia. And this was designed for schools, but we actually find adults like it too.
It's an 800-year-old document, written on dried animal skin, in England, on the other side of the world, in a language we no longer use, that most people couldn't read even back then. So why is Magna Carta important to us in Australia today? Because it was the starting point for some of our most important human rights, things it's easy to take for granted. For instance, before Magna Carta, life was pretty cruisy. If you were a king, you could get away with all kinds of things. Running your own armies, invading other countries whenever you fancied, and taxing people to pay for wars without even asking. Now, there were laws in those days, but some rulers believed they had absolute power and simply ignored them. That changed in 1215, when a group of landowning barons finally had enough of King John's behaviour. They decided the king governed by their consent, not just because he was king. So they got together and forced the king to agree to limit his powers by signing Magna Carta. It was the beginning of fairer rights for the people. The king also agreed he couldn't just add new taxes. Free men had to be represented by a common council to be taxed, which started the evolution of democracy. It also meant the king was no longer top dog, because above him now was the law. Or at least that was the idea. Kings and queens had a lot of trouble getting used to not being in charge. But over the next few hundred years, people power, in the form of Parliament, grew to be much stronger. In its Bill of Rights of 1689, the English Parliament formally decided it was the job of government to represent the people and protect their rights. These ideas came to Australia in English law. We know today if someone is accused of a crime, they have the right to a fair trial, and they must be proven guilty before they can be punished. Before Magna Carta, justice wasn't always applied fairly. Remember old King John? He was pretty good at filling up the prisons. But under Magna Carta, it was no longer up to him to decide whether someone had done wrong. It said, "No free man shall be seized or imprisoned, except by the lawful judgment of his equals or by the law of the land." Now you had to have a reason to lock someone up, and later people decided you also had a right to argue your case in front of a court. But in 1215, no free man didn't mean everyone, because in those days most people weren't free. They were poor peasants who served the lords. It took till the 16, 17 and 1800s before all men were free in Western countries, and most women waited until the 20th century. In 1948, after the atrocities of World War II, the nations of the world created the Universal Declaration of Human Rights. For the first time, the whole world recognised that everyone, it didn't matter who you were, had the right to enjoy freedom of speech, freedom of religion, and freedom from fear and want. It has been described as the international Magna Carta for all mankind. So, this faded old piece of animal skin has played a big part in shaping the democratic society we have in Australia today. But many people around the world are still denied their rights and freedoms. This reminds us human rights shouldn't be taken for granted. And until they are, the long story of human rights and freedoms that began with Magna Carta will continue.
Well, we're finding these really are fantastic. We use them a lot, and we use similar kinds of things for grown-ups, including training of public officials, border force officials, which is quite true. So we use these tools a lot, and do, if you've got time, go and have a look at our website. We've got a wonderful one on the power of oldness. But behind this and behind the work that we're doing is an extraordinary phenomenon. A colleague of mine, a lawyer, did a survey of Australians a couple of years ago to ask, do we have a constitution? And 60% of Australians said no. Then asked a second question, do we have a Bill of Rights? And 80% of Australians said yes. And a case a few weeks ago of a man who was being arrested by the police for killing his partner, yet another of these horrible cases of intimate partner domestic violence, when he was arrested, said to the police, "I want to take the Fifth Amendment." So that's why we're doing this, because although it seems simplistic, the truth is we do have to understand this a little better than we have done. I would like to finish, because I have used up my time, but I would like to finish with one that has been probably one of the most successful things we've done and are currently doing at the Commission, and that is running the nation's Racism It Stops With Me campaign. It's been very effective. We've now got something like 400 companies joining and signing up for the Racism It Stops With Me, funded by the federal government, and it's really been very good in both educationally changing understandings, but also creating a culture that racism, in particular, is not acceptable. And I'd like to finish then, if I may, with this one.
Racism
has no place in sport.
No place in sport.
Everyone
deserves a fair go, regardless of skin colour,
Background
or culture.
Racism! It stops with me!
It stops with me.
It stops with me.
With me.
With me.
with me.
Racism! It stops with me!
So I think, obviously, Adam Goodes has been a remarkable leader, and we need more like that to stand up and to call out racism when we see it, but also in other areas of ageism, of gender inequality, of the rights of children that my colleague at the Commission works on, and other areas of broad human rights. So can I conclude then by saying that I think Australia does have a piecemeal and very inadequate and exceptional approach to the incorporation of human rights obligations in domestic law. But human rights education has perhaps the major role in reimagining the world in which we live. It can empower us all to better understand the fundamental freedoms and rights that each of us possesses. It's about making human rights values part of everyday life. Education is the vital tool for reimagining the Australia that we want to live in, and I really value your coming tonight to listen to me. Thank you very much.